Here's a classic tree dispute. Red neighbour, blue neighbour. Blue neighbour owns a tree, branches are encroaching from that tree into the red neighbour's garden, across the pink boundary line. So what's the red neighbour able to do in law? Well, in law, the red neighbour is allowed, without permission, without putting the blue neighbour on notice, to cut the branches back to the boundary line. But whilst the red neighbour is allowed to do that in law, the court and judges would always ask for there to be a discussion between the neighbours before that happens, because the red neighbour, in taking on that work, actually adopts a duty of care in negligence to do those works reasonably. And obviously in cutting back branches, there's a risk of damage to the tree and to the long-term health of the tree. And there's also a risk of the red neighbour actually trespassing and encroaching themselves onto the blue neighbour's land. So discussion is the key here. But presuming they take the opportunity to go ahead with their legal rights and remove the branches, what can they then do? Well, not this. They shouldn't throw the branches over the fence onto the ground in the blue neighbour's garden. Yes, the branches do still belong to the blue neighbour as the tree owner, but they should be offered back to the blue neighbour to be disposed of at the blue neighbour's wishes. But through the heart of this is often the cause of a neighbour dispute. The heart of this, the court would ask there to be discussion between the two parties to cooperate about what happens with the tree. In the event that that sort of cooperation isn't possible, then an impartial third party, such as an arboriculturalist, should be instructed to see if a deal can be negotiated between the blue and the red neighbour to all live in harmony together with the tree.